My name is Esra Hudson. I'm a partner with Manat, Phelps & Phillips. I specialize in labor and employment law, and I am here today with my colleague Cherise Latortue.
Hello.
Cherise is also an attorney at Manat, Phelps & Phillips. And Cherise and I are going to be talking about the fate of confidentiality provisions in employment settlement agreements in the Weinstein era. It has been very prominently featured in the news of late that famous figures in society like Harvey Weinstein and Bill O'Reilly have had a history of engaging in sexually harassing conduct and settling claims brought by various individuals for significant sums of money, and then continuing to act with impunity, in part because of confidentiality provisions in settlement agreements. This has raised some public policy concerns and some efforts at both the state and federal level to initiate litigation to limit the confidentiality of agreements in the employment arena. Today we're going to be talking about those types of agreements, those types of provisions in employment agreements in general, what they typically consist of, and the current state of the law in this area and the limitations that already exist for confidentiality of these types of agreements. We'll also be talking about some of the policy and societal arguments for and against confidentiality in these types of agreements, and then discussing some best practices for how to deal with these issues going forward. So with that in mind, let's start looking at some of the typical elements of confidentiality provisions in employment agreements. The first element of these types of provisions is that they typically prohibit disclosure of the terms and conditions of the agreement. In addition, they typically prohibit even disclosure of the existence of the agreement in the first place. And where there has not been litigation initiated or a public filing of some sort, these provisions may also prohibit disclosure of even the underlying facts of the agreement. They tend to contain limited exceptions for a control group of individuals. So this would usually include someone like the spouse of the complaining party or the settling party, an attorney, an accountant. If the confidentiality provision applies to the company as well, it might exclude people who need to know for business reasons about the settlement agreement. There is almost always also a carve-out for responses to subpoenas or other legal process. Except for those rather limited exceptions, for the most part, the confidentiality of these types of agreements is otherwise absolute. Sometimes the confidentiality provision will also include authorized language to describe the resolution. So the parties will come up with some phrase that they both agree will be appropriate and allowed in order to describe the resolution of the litigation or the dispute. And it's usually something very neutral, like, we have reached a resolution of this matter. Not much more than that is usually permitted. And then finally, these provisions may contain some consequences for breach, and what those consequences are varies. Sometimes liquidated damages provisions are included. Other times there may be a provision that provides that confidentiality is a material term, and a breach of the confidentiality provision will require a refund of the settlement proceeds. Other times there is no specific remedy, and the language is merely that a breach is a material, a breach of the confidentiality provision is a material breach of the agreement in general. So with that in mind, why do parties want to keep employment settlement agreements confidential? Why is this important to both an employer and an employee? Well, from an employer's perspective, it's obvious. To a certain extent, any kind of settlement from an employer's perspective may suggest to employees a willingness to settle. And employers are often concerned that if they settle claims, that it will breed further litigation. And they want to avoid doing that. Another reason that employers might want to keep these agreements confidential is to avoid any inference of an admission of guilt. Sometimes there will be a conclusion drawn that if the employer or the company felt that the claim had no merit, they would have litigated it, and a settlement agreement suggests that they felt there was some culpability there. Companies may also seek to settle these types of claims confidentially to avoid inflating the expectations of other litigants. When a settlement agreement is entered into, it typically contains very little information about the underlying facts, if any. Sometimes only the nature of the claim itself will be contained in the settlement agreement, sometimes not even that. And if there are certain dollar amounts reflected in the settlement agreement without any explanation of the factual background or the employer's position on liability, companies may be concerned that simply the dollar amounts themselves will suggest to other litigants that that is a typical range of settlement for the company. Employees, though, also have an interest in keeping settlement agreements confidential, particularly in claims related to their employment and their issues that may raise concerns about privacy. Employees sometimes do not want subsequent employers or other people in the workforce to know that they were even in a dispute with their employer, and they may also wish to keep those agreements confidential. Sometimes the nature of the claims are sensitive. An employee might feel that they are embarrassing, and they don't want to share that they even brought a claim with anyone else, and have a significant interest in making sure that the entire dispute remains entirely confidential. And in those cases, the employee may request or insist on confidentiality. Confidentiality can also help the employee sometimes add value to the settlement or induce the employer to engage in settlement discussions with the knowledge that the conclusion of the agreement and the settlement of the claim will bring closure to both sides. So there are incentives both for the employer and the employee to have confidentiality in these types of resolutions. So what are the remedies for breach of a confidentiality provision? Because it's one thing to have a confidentiality provision in an agreement, it's another thing to try to enforce those provisions. Again, as I said earlier, liquidated damages sometimes are included in these types of provisions, return of settlement monies. Injunctive relief is sometimes included in these agreements and can be enforced to prohibit further breaches of confidentiality. Sometimes there are provisions included to relieve one party or the other of their obligation to continue to perform under the agreement if the breach was material. These types of provisions often occur when there is an ongoing payment obligation in the settlement agreement. If the settlement agreement is continuing to be enforced pursuant to California Civil Code Section 6646, which gives the court ongoing jurisdiction to enforce a settlement agreement, then a remedy may be a motion to enforce the settlement agreement under that provision. And then finally, a lawsuit for breach of contract is a remedy for breach of a confidentiality provision. So Cherise is going to talk now about some of the policy and broader implications of having these types of agreements, particularly in sexual harassment cases, be confidential.
So the question that comes to mind after learning about why parties and employer-employee may want to enter into a settlement agreement should there be a settlement? Should there be confidentiality provisions in these type of settlement agreements, especially in sexual harassment cases? A lot of arguments against no confidentiality provisions in sexual harassment cases focus on the fact that these confidentiality provisions keep systematic wrongful conduct secret. And this is what we're seeing repeated in a lot of the media coverage in the prominent public figures or celebrities where these allegations are coming to the forefront. These conduct or the allegations of conduct have been going on for quite some time. And a lot of the public outcry or these media reports have been focusing on the fact that had there not been these confidentiality provisions, would these allegations have come to the forefront a longer time ago, and could some action have taken place prior to kind of limit the sexual harassing conduct or to bring to light these kind of this conduct, which brings me to the second point of it limits the ability of enforcement agencies to protect the public. And some of the arguments is that these ongoing systematic allegations of sexual harassment creates a public hazard. And we see these arguments coming up time and time again, especially again in the public forum against, the prominent figures such as Roger Ailes or Harvey Weinstein. The impact on the public, these people who are working for the Weinstein company, who are interacting with Harvey Weinstein, for example, had there been no confidentiality provisions in settlement agreements or even non-disclosure agreements, the public would have been aware of the person or the company they were dealing with. Another argument against these confidentiality provisions includes it keeps the victim silent. So the confidentiality provisions, and we've just discussed the remedies for breach of confidentiality, they entice the person who's making these sexual harassment allegations to remain silent because there's a consequence for breaching that confidentiality provision, or even if it's a confidentiality agreement. Some of these confidentiality provisions violate certain state laws which prohibit secret agreements in certain situations. And we'll talk a little bit more later about what is termed Sunshine and Litigation Acts, which prohibit secrecy agreements or confidentiality provisions in certain situations. And we're seeing a rise of the Sunshine and Litigation statutes being applied to sexual harassment cases when there's rampant allegations of sexual harassment. Another argument against these confidentiality provisions includes that it undermines the ability to evaluate the value of the case. So as Esra mentioned before, there's very little discussion about the underlying facts in these sexual harassment cases. And so there's no real deep dive into the allegations, the response to the allegations. And so it's difficult to determine the value of these cases because once the settlement agreement has been entered into and with confidentiality provisions, there's no further discussion about the underlying facts, the fact that there was a settlement agreement. The other argument against confidentiality provisions includes, which ties into all the other arguments we've mentioned before, is the legal system is a public trust. So overarching, even though these agreements tend to be between private parties, at the end of the day, there's still the public that's being kept out of these settlement agreements, these confidentiality provisions. And so the legal system is meant to address and protect the public. And the arguments against these confidentiality provisions is that the settlement agreements do not address the public trust in the legal system, and whenever these private entities or these private parties enter into these settlement agreements that contain confidentiality provisions, there should be some public scrutiny or public access to these agreements so that the public is aware of, one, the allegations that are brought forth, and two, what can be done to protect themselves. But confidentiality agreements, as proponents against confidentiality provisions argue, is that it disallows the public from analyzing, evaluating, and assessing the underlying facts for these cases. We see these arguments coming to the forefront, as I've mentioned, in the onslaught or the rise of sexual harassment allegations against very prominent public figures and celebrities. We're talking Harvey Weinstein, Roger Ailes, and it's not just the individuals, it's also the companies that these individuals worked for. So the widespread allegations of sexual harassment against these prominent figures have fueled the debate on whether private entities, private parties should enter into confidentiality agreements or settlement agreements that contain confidentiality provisions in the first place. Several media reports have highlighted the impact of confidentiality provisions and have advocated against non-disclosure agreements before there's even an allegation of sexual harassment. There are a lot of companies, a lot of employers that require their employees, because of the nature of what they do, to enter into non-disclosure agreements which prevent employees from talking about anything that's disparaging or anything that can be a negative impact into the company, and take it beyond that when there is an allegation of sexual harassment and they enter into settlement agreements, covering those, protecting the public disclosure of any such facts to the public. Some of these arguments, they're the same arguments we see at the forefront when we talk about whether we should even enter into these confidentiality provisions in the first place. And they include the fact that confidentiality, especially in sexual harassment cases, they buy silence from the victims. And we've seen this in the media reports from the New York Times, from Forbes, from Vox, that these victims, dating back 20, 30 years, they've remained silent for a variety of reasons, but including the fact that they have entered into either non-disclosure agreements or settlement agreements that contain confidentiality provisions that prevent them from disclosing any of the underlying facts that support or give rise to their allegations of sexual harassment. A lot of the other arguments include the fact that these confidentiality provisions, they run afoul of a variety of government agency laws, including the National Labor Relations Act. Just to delve a little bit deeper, the National Labor Relations Act prohibits employers, among other things, from preventing workers from talking about sexual harassment or even gender inequity complaints at work or when they relate to work. This comes about when we hear a lot of these victims dating back 20, 30 years of these ongoing complaints of sexual harassment or these ongoing conduct of sexual harassment, why they didn't talk about it in the first place, why they didn't talk to each other. One of the outcry against these confidentiality provisions is that it prevents employees within a company from talking to each other about the conduct that they're facing in the workplace. And the argument is that these confidentiality provisions run afoul of laws that are in place, whether it's federal or state, to enforce and implement, which encourages employees to interact with each other and consider action to address the workplace conditions. In the same line, there's the Title VII of the Civil Rights Act, another federal law which is enforced by the Equal Employment Opportunity Commission, or the EEOC. And there's argument that these confidentiality provisions also impede the enforcement of Title VII by the EEOC when they prohibit settling employees from filing charges or assisting the EEOC in an investigation. So one of the things that Esra had mentioned earlier is that the elements of a confidentiality provision within a settlement agreement may include not talking about the agreement, the underlying facts, but it also could prevent or include a provision that prohibits the employee from taking the claim to a government agency, including the EEOC. And so one of the arguments is that these confidentiality provisions preclude the EEOC's enforcement of Title VII. Employment laws, and this is more of a societal argument, enforcement laws are under-enforced by government agencies. It's a resource argument. Like, these government agencies don't have the ability, whether it's financial, whether it's manpower, to enforce a variety of their own laws. And so that falls on private entities, usually the Human Resources Department or the Compliance Department of private entities, to enforce federal and state laws which prohibit harassment and discrimination, including those based on sex. But the problem is, well, not the problem, but the argument set forth is that these Human Resources Department or compliance departments, they are weak in enforcing these laws. And so there's no real investigation or enforcement or getting to the bottom of these facts when these allegations raised. And so confidentiality provisions prevent further investigation and ultimate enforcement of the laws that are meant and are in place to protect against these kind of conduct in the workplace. Another thing that has been reported in the wake of these allegations of sexual harassment is the confidentiality provisions jeopardize the public, and we will see this theme running throughout, even in laws that prohibit certain settlement agreements from prohibiting discussion of sexual harassment, is that these confidentiality provisions jeopardize the public, including other potential victims, and allow perpetrators to escape justice. So the argument is that in not talking, in being prevented from talking about the underlying facts, not just about the settlement agreement, but the underlying facts itself, prevent other victims from coming forth, prevent law enforcement agencies from investigating and enforcing, and also prevent the ability from a bigger picture from even the private entities, the Human Resources Department, from seeing a pattern of conduct that they should be aware of. The other argument that's brought up, and again, they're all tied into each other, is that employers' liability for violating anti-discrimination and civil rights statutes for not taking appropriate action to remedy sexual harassment. So the argument is that when you enter into a settlement agreement that contains a confidential provision, employers are really escaping liability from the sexual harassment or the inappropriate conduct that's taking place in the workplace. And there's an argument that the employer itself should be held liable for these inappropriate conduct. And for example, Forbes reported that the New York City Attorney General is investigating the Weinstein company to determine whether the company was in violation of any civil rights or anti-discrimination laws. So it's beyond the actual perpetrator or the alleged perpetrator. It's what the employer knew and what acts or steps the employer took to prevent further inappropriate or sexually harassing conduct in the workplace and against the specific alleged harasser. There's also an actress by the name of Dominique Huet who's reportedly sued the Weinstein company, alleging it knew of Harvey Weinstein's inappropriate behavior and failed to take action. So we will likely see these kind of claims or these lawsuits when there's been evidence of systematic settlement agreements in place that contain confidentiality agreements which prohibit the alleged victims from complaining or talking about prior acts of sexually harassing conduct. And in light of this, there are some legal limitations to confidentiality provisions, especially in the employment area and employment settlement agreements, and Esra will talk a little bit more about that.
Just to talk a little bit about the flip side, Cherise has talked a lot about public policy and societal interests in keeping settlement agreements in this area not confidential and having the information publicly available. On the flip side, there is also a public policy in favor of resolving disputes and in favor of settling claims in lieu of litigation and ensuring that settlements are final once they are entered into. And while there has been a lot of discussion recently in the media about questioning the appropriateness of confidentiality provisions in these types of agreements. There has also been a counter argument that doing away with confidentiality and the ability of the parties to voluntarily enter into confidentiality agreements undermines the ability of both parties to settle and resolve cases and provides a significant disincentive for companies in particular to resolve cases short of litigation. And there is a countervailing concern that has been discussed increasingly in the media as well about balancing these two interests and ensuring that on the one hand, systematic perpetrators of sexual harassment in the workplace are not protected, especially those who have significant financial means, while at the same time ensuring that that companies and employers are not entirely disincentivized from finding reasonable ways to resolve claims and for ways to dispose of claims that are not meritorious. So with that in mind, I will say that notwithstanding that concern about ensuring that people can still resolve claims if they want to and keep those claims confidential, the pendulum is swinging towards doing away with confidentiality provisions in settlement agreements. They can still exist today, but in certain contexts there are some significant limitations to them that are already and have been being developed in the law. One area in which that has become true is in financial litigation involving securities traders. The Financial Industry Regulatory Authority, or FINRA, requires that confidentiality provisions in settlement agreements expressly authorize employee communications with securities regulators such as the SEC, and that is Regulatory Notice 1440. The FINRA issued a reminder of this rule in October of 2014. Well, they called it a reminder, but it actually went a step further than prior guidance. It used to be that confidentiality provisions only needed to state that they don't prevent a party from responding to a regulator upon inquiry. But following the reminder in October of 2014, FINRA made it clear that securities firms have to explicitly notify signatories that confidentiality provisions do not limit their ability to initiate contact with regulators. So it's not just that they're authorized to respond if a regulator comes knocking on their door. The new guidance makes it clear that signatories to these types of settlement agreements can affirmatively seek out the SEC and make a disclosure without violating a confidentiality provision. And that is a theme that will see over and over in a variety of different regulatory contexts, in part because of one of the concerns that Cherise noted, which is that the regulators just don't have the time, money, or resources to go knocking on doors and rely in large part on employees to knock on the door for them and tell them that there are issues, regulatory issues, both in anti-discrimination and harassment laws and whistleblowing and financial regulations that were passed within the last 10 years following the financial crisis. In that vein, Rule 21F-17 of the Dodd-Frank Act prohibits enforcing or threatening to enforce confidentiality agreements that prohibit whistleblowers from communicating with the SEC or receiving a whistleblower award. This particular rule has been increasingly and actively enforced by the SEC to such an extent that it essentially has limited the ability to include any kind of confidentiality provision at all in a case where the SEC might have some sort of interest. The first enforcement action under this rule was in April of 2015 against a company for using overly restrictive language in a confidentiality agreement. In August of 2016, the SEC settled another enforcement action against Blue Links Holdings for overly broad confidentiality language in its severance agreements. The improper provisions, according to the SEC, required employees to waive their right to monetary recovery if they filed a charge against the SEC. And it also required the employees to notify the company before making an authorized disclosure in a regulatory proceeding. The SEC said that the company could not require any kind of advance disclosure, and they could not require any kind of waiver of monetary recovery. So then you might ask yourself, well, what good is it to settle a case with an employee if the employee still has a remedy to get monetary recovery against the company through an SEC charge following the resolution of the whistleblower claim? And that is a good question, and one that the SEC is not really concerned about. The fact is, according to the SEC, the only limitation is that the employer can provide for in a settlement agreement with a whistleblower is an individual claim against the employer itself, but not any kind of award that the employee could get through an enforcement action. As part of the resolution with the SEC, Blue Links had to agree to add the following language to its severance agreements. Employee understands that nothing contained in this agreement limits employees' ability to file a charge or complaint with the Equal Employment Opportunity Commission, the National Labor Relations Board, the Occupational Safety and Health Administration, the Securities and Exchange Commission, or any other federal, state, or local government agency or commission, which they called government agencies general. So basically, according to the SEC, that the Dodd-Frank rule prohibits employers from limiting employees' abilities to file a charge with essentially any government agency that regulates the employment industry. The provision further goes on to say the employee further understands that this agreement does not limit employees' ability to communicate with any government agency or otherwise participate in any investigation or proceeding that may be conducted by any government agency, including providing documents or other information without notice to the company. This agreement does not limit employees' right to receive an award for information provided to any government agency. So this rule, which went into effect August of 2016 following the Blue Links case, significantly limits the ability of employers to include broad confidentiality provisions in employment severance agreements. OSHA further issued a policy guidance in September of 2016 regarding the approval of settlement agreements under OSHA and also the Sarbanes-Oxley Act. You may not know that the federal enforcement agency that is charged with enforcing the Sarbanes-Oxley Act is OSHA. The OSHA guidance says that OSHA will not approve settlement agreements that prohibit or inhibit employees from providing information to the government, requiring advance notice to employers before communicating with the government, or that award disproportionate liquidated damages. Cherise is now going to talk about some of the other statutes at the state level that limit confidentiality in certain circumstances.
And so one of the state-specific limitations to confidentiality provisions in settlement agreements includes Section 1002 of the California Civil Code of Procedure. This statute specifically prohibits settlement agreements that prevent the disclosure of factual information which could possibly establish a cause of action for the prosecution of the following causes of actions on the prosecution of these acts. An act that may be prosecuted as a felony sex offense, an act of childhood sexual abuse, an act of sexual exploitation of a minor, an act of sexual assault against an elder or dependent adult. The Section 1002 of the California Civil Code of Procedure further prohibits courts from entering an order that restricts the disclosure of the above information. So this is California statute not only prohibits private parties from entering into settlement agreements that prohibit the disclosure of these kind of factual information, but it also prohibits courts from entering or enforcing these settlement agreements. That includes confidentiality provisions that preclude the disclosure of this kind of information. So this limitation usually comes about in allegations against an employer, against a supervisor, or against an employee of a company where the underlying facts could possibly give rise to prosecution or cause of action in a different context and the specified acts. The Act was also recently amended. So effective earlier this year, January 1st, 2017, the Act further provides that any settlement agreement preventing disclosure of these factual information is void as a matter of law and against public policy. So as a matter of law, any settlement agreement that contains a confidentiality provision that precludes the disclosure of factual information giving rise to these possible causes of action are void as a matter of law and against public policy. So again, the Act is further prescribing against courts and even attorneys from entering into these kind of agreements. And again, the Act takes it even further. So it's not just the courts, it's not just the private parties, but also attorneys who fail to comply with these statutes by demanding that certain confidentiality provisions be included in settlement agreements where these kind of factual information arise. Those attorneys can be subject to professional discipline by the State Bar of California. And the Act further contains a provision that requires the State Bar of California to investigate and to take appropriate action in any such cases brought to its attention. So we've discussed at length the public and societal reasons for not entering into these confidentiality agreements for a variety of reasons, but we are seeing both on the federal level and on the state level that there are prohibitions against confidentiality provisions in certain type of allegations of sexual harassment. And it's not just the state of California, it's also a variety of other states. Just to give additional information on Section 1002 of the California Code of Civil Procedure, there's even further amendment to that section that will become effective most likely next year that makes it easier for courts to limit the enforcement of these type of settlement agreements that contain these confidentiality provisions, and further makes it easier for the State Bar of California to take disciplinary actions against attorneys who demand these types of confidentiality provisions. So there are states that are taking action which may not necessarily be at the federal level or just may not be enforced just as a practical matter. There are states that are taking the step further to ensure that the public on the whole is protected against certain types of sexual harassment or sexual conduct allegations in the workplace. There are a variety of other states that have enacted what we call sunshine and litigation statutes or sunshine and litigation acts. These states include Florida, Arkansas, Indiana, North and South Carolina, Nevada, Ohio, Massachusetts, Washington, Michigan, Virginia, Delaware, Georgia, and Texas. And what the sunshine and litigation statute of the Act provide, just generally, of course they will be specific for each state, but what they provide on a general level is that settlement agreements cannot have an effect or cannot include confidentiality agreements that conceal a public hazard or any information containing a public hazard. And while it does not pertain specifically to sexual harassment cases, there's a lot of argument being made that rampant sexual harassment allegations against either a specific individual or within a certain company should not be silenced or included within a confidentiality provision in settlement agreements, or employees should not be precluded from talking about this kind of conduct in non-disclosure agreements, for example, to the extent that these allegations present a public hazard. And we see, while we have not seen specific state courts enforcing these sunshine and litigation acts in particular sexual harassment cases, we can anticipate or we can imagine that the rise of sexual harassment allegations against a particular individual, especially higher up in the corporation that a particular individual is, a supervisor, manager, executive, the argument can be made that silencing a variety of employees from disclosing alleged acts of sexual harassment or sexually charged conduct in the workplace does create a public hazard, and confidentiality agreements should not be used to prevent the disclosure of this kind of information. So the purpose of these statutes I've mentioned before is to prohibit parties to a settlement agreement from being able to hide people, the alleged harassing individuals or conditions, which is the alleged harassing conduct, that may be deemed dangerous from the public consciousness. In the employment context, the argument is that sexual harassers are arguably individuals and workplace conditions are arguably the conditions that may exist that can cause injury to the unknowing public and create a public hazard. Conceivably, as mentioned earlier, that these sunshine and litigation statutes can prohibit confidentiality agreements in the employment context on the grounds that sexual harassers, and we're not just talking about one incident or a discrete incident, but we're talking about allegations where you see the same allegations against most likely the same individual, arguably public hazard that should be precluded from confidentiality provisions in the workplace. Specific to the state of California, California Senator Connie Levia, who is a representative from Chino, has proposed a bill to ban confidentiality provisions in settlement agreements. So one of the states that I did not list that has a Sunshine and Litigation Act is California, but there is a bill currently presented to include a Sunshine and Litigation Act in the California law. Senator Levia, when she announced the bill in October of this year, 2017, she stated that secret settlements in sexual assault and related cases in workplace and other settings can ultimately endanger the public by hiding sexual predators from law enforcement and the public. So we're seeing here where there's a deliberate tie between sexual harassment cases and the potential danger placed to the public or public hazard by keeping these allegations of sexual harassing conduct secret by including them in confidentiality provisions. Senator Levia went on to say that the stated purpose of the bill is to ensure that sexual predators can be held accountable for their actions and ideally prevent them from victimizing others. It will be important to note, or interesting to note, that Senator Levia previously authored previous litigation that were signed into law by the governor of California to eliminate the statute of limitations on rape cases, which was Senate Bill 813 in 2016, and she also previously authored legislation to criminalize sextortation in 2017, earlier this year, Senate Bill 500. And one of the another interesting development is on the federal level. So there's nothing in the federal statutes that pertains to the Sunshine and Litigation Act. But earlier this year, in February 14, 2017, there was a proposal to introduce a limitation to federal discovery statutes pertaining to confidentiality agreements and protective orders, which would include an exception or carve out to these protective orders that would limit a court from entering a protective order or from sealing certain documents to the extent that the underlying facts gave rise to a cause of action or even just a series of acts that could possibly endanger the public, or if in weighing the interest of the entities or the parties who wanted to keep that information private as compared to the public's interest in having access to this information, the court will take a balancing act and weigh the interests of the public in getting this information and the parties in keeping this private. Because as Esra mentioned earlier, there is some interest on both the employer side and the employee side in entering into settlement agreements with confidentiality provisions. And so there's a bill on the floor now that would amend current existing federal discovery laws to limit the imposition or enforcement of protective orders where the underlying facts could potentially place the public at public in danger or the public at hazard. This law has been presented to the committee in the White House for quite some time. This is the 7th year that it's been introduced. The likelihood that it would be presented to the House or the Senate or even passed is low, given the commentary and the input onto the bill, basically because the argument is that there are so many laws, both on the state and the federal level, as I have discussed and Esra has also gone through, that already limit the scope and the nature of confidentiality provisions in settlement agreements or even non-disclosure agreements, especially in sexual harassment cases or other type of cases. And in light of public commentary on whether confidentiality agreements should be enforced and the reasons why an employer or an employee will enter into confidentiality provisions given the underlying facts, Esra will now talk about the best practices for entering into these or drafting confidentiality provisions, settlement agreements, and non-disclosures, especially in the wake of these interesting facts that are coming to the forefront.
So before I get into best practices, I want to talk about a couple of other cases under the SEC's purview. As I mentioned earlier, the SEC has been one of the most aggressive enforcement agencies in striking down, undermining, and fining companies for having confidentiality provisions in settlement agreements or even employee severance agreements. And there are a few that I think are worthy of note and that will be helpful for companies and employers to be aware of when drafting settlement and severance agreements. In January of 2017, the SEC entered into a fine against BlackRock, Inc. of $340,000, and that fine was to settle charges that it improperly used severance agreements in which existing employees were forced to waive their rights to receive whistleblower awards. Now, the award didn't say, the severance agreements didn't say anything about confidentiality at all and didn't necessarily require the employees to remain confidential, to keep the information that may have been underlying their claims or really any aspect of their employment confidential. But the SEC took the position that because there is a waiver of an award to bring a whistleblower claim included in the severance agreement, it essentially acts as a disincentive for employees to contact the SEC and a disincentive to have them directly communicate with the SEC, and that in and of itself, according to the SEC, violated the no confidentiality provisions of the Dodd-Frank Act. Another case that ended up in a significant fine from the SEC was against Neustar, Inc. That case also did not include a confidentiality provision, but instead included another provision that is sometimes a companion of a confidentiality provision and is included in many, if not most, settlement agreements in the employment arena, and that is a non-disparagement clause. This particular severance agreement, and this was included in the standard severance agreement that any Neustar employee would receive if they departed employment and were provided severance. The non-disparagement clause prohibited employees from communicating information that disparages, denigrates, maligns, or impugns News Star to others, including any agencies or government entities, which would have included the SEC. And the non-disparagement provision included a forfeiture clause that the employee agreed would any kind of disparagement would cause irreparable injury and damage to News Star, and it compelled the forfeiture of the entire severance amount except for $100 in the event of any such breach. And the SEC said that provision was illegal and required News Star to pay $180,000 and change its severance agreements going forward. So the SEC is not just enforcing these types of provisions when there is an actual dispute or a whistleblower issue that it is enforcing. It's looking at severance agreements broadly that employers are using, standard form contracts, and where it finds violations, it is issuing fines and requiring companies to rewrite those types of severance agreements. So on the issue of best practices, what we're seeing is an increasing challenge to confidentiality provisions in employment, severance, and settlement agreements. It began in recent years with the enforcement agencies like the EEOC, OSHA, and the SEC and FINRA, and it is now increasing in the wake of these very public allegations of ongoing and systemic sexual harassment by some very prominent individuals and some of the biggest companies in the country. With this increasing attention to confidentiality provisions, I think we can all expect that they will become challenged even more, not just by the enforcement agencies, but by private individuals. Both those individuals who are subject to these confidentiality provisions and third parties seeking access to information about prior severance and settlement agreements involving these types of allegations. So what does that mean for companies and employers going forward? How can they take steps to protect themselves and ensure in certain circumstances where confidentiality may be warranted, these types of provisions will be enforced? Well, first, include carve-out provisions for complaints to government agencies such as the EEOC, the SEC, the NLRB, and the others we've talked about today. Make clear that nothing in the agreement in general prohibits employees from contacting these agencies. If the agreement includes a waiver of any kind of monetary award, keep in mind that if that gets before the SEC is going to absolutely require a change to that provision and may even issue a significant fine if that type of provision is included. It may be best just to say nothing about an award one way or the other, rather than affirmatively require employees to forego awards if they receive them for contacting or whistleblowing to an enforcement agencies. The other thing is to prepare for the eventuality that confidentiality and settlement agreements involving things like harassment and discrimination may be increasingly limited in this context. And to the extent that happens, it's important to try to limit the situations in which these types of agreements are even necessary. Ensure that policies and procedures are in place to nip unlawful conduct in the bud in the first instance. Where if there is a confidentiality provision in an agreement, ensure that people who are on a need-to-know basis and are responsible for enforcing these types of laws in the workplace have access to the information so that they can help prevent ongoing or continuing conduct by the same individuals. Consider disciplinary action that will be imposed on alleged harassers to ensure that they don't engage in further conduct, so that if you have an agreement and it becomes known that is the only circumstance in which the harasser either was accused or engaged in such conduct. If there is a concern about a particular agreement's confidentiality provision being enforced, it may be important for the company to include some facts and the nature of the denial of liability, rather than a straightforward denial. No admission of liability language that is typically used in these agreements. There might be circumstances in which it is in the interest of all the parties to include, particularly the employer, to include more facts to explain what the defense would have been had the case proceeded to trial, so that there isn't a suggestion that the settlement was made because the employer feared liability. I think these are some of the ways that we can start thinking about confidentiality provisions in these agreements. They are still enforceable. They will continue to be enforced in many contexts. They can be powerful incentives both to resolve disputes and to ensure the finality of settlement agreements. But the increasing challenge to them is something that will have to be considered when drafting going forward.
Absolutely.
One of the things we talked about earlier are the various remedies that are often included in settlement or severance agreements for breach of confidentiality provisions. One thing that we should discuss here is the likelihood of those provisions actually being enforced, and practically how often they are enforced, and what makes people maintain confidentiality, notwithstanding some of the potential challenges to enforcing these provisions, nonetheless. Any thoughts on that, Cherise?
Yeah, absolutely. I think that especially again, taking it back to the wake of the Weinstein era, for example, where a lot of the allegations against Harvey Weinstein were brought to the forefront by employees who breached their non-disclosure agreements or even their settlement agreements to break their silence against Mr. Weinstein. And we don't see Mr. Weinstein enforcing those settlement agreements or enforcing those non-disclosure agreements. We can speculate as to why, but there are a variety of reasons that we can certainly deduce the fact they're very public. And so his incentive to now go back and enforce these settlement agreements or the non-disclosure agreements and basically blame the victim or pursue the victim or the alleged victim for breaching their settlement agreement when he's already publicly apologized for his conduct is very impractical. From a public relations standpoint, the cost of enforcing these confidentiality agreements after they have been breached certainly outweighs the breaking of the silence that these victims are coming across with. We've also seen the derailment of Senator Kane's presidential candidacy in a couple years ago when he, disparaged a lot of women who were coming to the forefront and accusing him of sexual harassment. He went off against them, and he also basically denied ever entering into settlement agreements with them. And the undertone of those of his response to the allegations was, you shouldn't have been talking about any of these things because we entered into these settlement agreements. So there's certainly a public relations cost, especially when the alleged harasser is at the forefront in the public, where the person is a celebrity, but also what is it going to cost the employer or the person itself from a financial perspective from pursuing from enforcing these provisions. In the most common language is the cat is already out of the bag. So what are you going to gain from going after these alleged victims and pursuing and enforcing these confidentiality provisions?
So what is the employer's best practice in light of the fact that these provisions are being increasingly challenged and are difficult to enforce in the first instance?
I think it raises one of the things that you mentioned, having policies and procedures in place in the first instance, when these allegations come to the forefront, the investigation, the drafting very narrow settlement agreements. And I think that once you give the impression or you have an environment where employees feel, one, that they are protected by their employer and their work environment is a safe place, we don't even get to the point of breaching these confidentiality provisions, because we have to consider at the end of the day, employees also want to keep their privacy private, and so there may not be an incentive other than they're seeing these people, in the public, or they're seeing the alleged act going on and on and on. Most employees want to keep their private life private, and I think that if the employers take these remedial steps and have great policies and procedures in place, that we don't even get to the point of breaching these agreements.